Hello, everybody. My name is Len. I am the host of Targeted Justice v. Garland, a podcast about an extraordinary lawsuit. And this is episode 44, I think. And with me today, my co-host, my co-pilot, an attorney for the plaintiffs in this historic case, Anna Toledo. Anna, please say hi.
Hi, good morning. Good morning. So happy to be here again. You know that you're my highlight of my week. So thank you so much.
So is mine. Today's legal segment is devoted to the question that I always wanted to address. How does the TSDB, the Terror Screening Database, is connected, related to the Patriot Act, which is also a question that a lot of viewers want to know. As I mentioned, this question actually came from several listeners. One of them was Robin D. On Substack, who is asking, doesn't the Patriot Act state of emergency support the use of the TSDB information for any purpose that they want? The short answer is no, but for a longer question, you will have to watch the Sunday episode. This is the Sunday episode. This is from you, Anna. This is from your commentary. Many think that TSDB is the child of the Patriot Act, included in its provision. This is not the case. While the Patriot Act was an act of Congress, the TSDB was not. Let's take a closer look. The Patriot Act chronologically was preceding the TSDB. It was enacted as an act of Congress in 2001, and it was called Uniting and Strengthening America by Providing Appropriate Tools Required to Intercept and Obstruct Terrorism. Right? That's a mouthful. But the main provisions in the beginning were expanding surveillance abilities of the law enforcement, including tapping domestic and international phones, easier interagency communication to allow federal agencies to more effectively use all available resources in counterterrorism efforts, and increase penalties for terrorism crimes, and an expanded list of activities which would qualify for terrorism charges. That is what was passed in 2001. But with the passage of time, the Patriot Act was redesigned and reformatted. And very few provision remains. Even the name of Patriot Act was actually taken away because it's divided into different acts. And many provisions of that Patriot Act were declared unconstitutional. For example, you, Anna, gave me an example. The sneak and peek warrants that allowed for delayed notification of the execution of search warrants were struck down by Judge N. Aiken on September 26 of 2007 after a Portland attorney, Brendan Mayfield, was wrongly jailed because of these searches. I am not familiar with this case. Please tell us a few things about it. This is extremely relevant to our proceedings.
Yeah, particularly because I don't think they have ever stopped doing the sneak and peeks. They continue to do them. They just don't tell people. And they have been using, the FISA juncture, which is empowered by the Patriot Act. The FISA Act became much more powerful after the Patriot Act. So I do think that they still do the sneak and peek. That's part of how they go into targeted individuals' houses and move things around and do their little thing of, how they steal trinkets and steal things to do the psychological operation. So I think that even though officially the sneak and peeks have been declared unconstitutional, I think the FBI is still doing them.
Yes, and this is so important about this entire situation. On the paper, a lot of things are illegal. We still have the Fourth Amendment, but de facto, we don't have it. So if you really want to take the Fourth Amendment away, just go through the process, come out and say the Fourth Amendment is not the law of the land anymore. And we're the victims, we're the recipients.
You see, because they have been acting in the catch me if you can attitude. because since law enforcement is in on it, when you report, for example, that somebody came into your house, they immediately turn your delusional card on you, because it's all a RICO act. Then what's going on here? There is a collusion of law enforcement and private entity to violate people's civil rights and people's Fourth Amendment rights, and they're all playing this game like, you're just delusional, and that's unfortunately, but that's how it goes.
The Patriot Act mainly provided for unlimited funding of counterterrorism initiatives, and including creation and funding of terrorist screening center. So it provided the funding for it, but it didn't authorize it.
As you know, in the 80s and the 90s, the big budget of the United States, it was all going for drug fighting, drug enforcement, DEA, da, da, da. And then they turned, from drug enforcement, they turned the enemy into terrorism. And that's where the money is, all the money coming from. And in the fear mongering, the terrorists. So it is about the money. And the people that collaborate with this, and all the private enterprise involved in the targeting of individuals, it's all about the money. It's all about getting money.
Yes, that's why you said they all want a piece of the cake. And we understand the motives of people who are not motivated by complying with the Constitution, but they're motivated by obtaining more money, draining more money from the U.S. government.
One of the important parts of the Patriot Act is also, you have to understand, this statute amended a lot of other statutes, like banking statutes, crime statutes. And one of them that they did was wanting to make sure that nobody was financing terrorism activities. And it implemented a lot of regulations for banks that banks had to implement to make sure that, for example, no terrorist was opening bank accounts. There was no money being transferred, wire transfer for the funding of terrorist activities. But what that trickles down to, in the context of what affects you and me, is that targeted individuals that are in handling codes 3 and 4 find it hard to send a simple $300 transfer of money through Western Union, because they have interpreted this, they have weaponized, let's put it that way, the interpretation of this law into, a simple, from real big money laundering to a simple wire transfer to a relative. And that's how they have made it a weapon against innocent Americans that have been illegally placed on this list.
Yes, correct. We know that the financial activities, our financial activities, our electronic activities, our daily activities are interrupted.
This is what I was mentioning before, how it made the FISA court so much stronger, because it allowed for the FISA court to go after American citizens. And that was not the purpose of a FISA court to begin with. So even though remove the statutory requirement that the government prove a surveillance standard on the target is a non-US citizen and an agent of a foreign power, now anything goes. And that is why the FISA court is currently undergoing a process with the FBI, doing like a stricter supervision of their procedures, because they don't comply with what is called the Woods procedure, which is how they're supposed to prepare cases and present them and submit that to the FISA court to obtain warrants. It was pretty much like submit the application, it was signed off, and it was granted to them. And that's how a lot of abuses have happened, including the 200,000 assessments, improper assessments that Christopher Wray, he was grilled on that this last week in Congress, because they were illegal against American citizens and residents.
I urge everybody to look up one of our previous podcasts where we played that senator from Utah, Mike Lee, and the Christopher Wray's responses were so misplaced that Michael Lee was knowing exactly the arguments that he was saying, and he was literally shaming him. He said, your defense that you present here is absurd. You don't tell anybody who is on the list, and yet you want people to challenge its constitutionality. This is an absurd argument. That was a beautiful moment. Further, many provisions, such as Section 204 and 209, that expanded search warrants were also expanded with the Act amending Title III of the Stored Communication Access Act to allow the FBI to gain access to stored voicemail through a search warrant rather than through the most stringent wiretap laws. Can you tell us the difference between access to information versus what it used to be before?
Well, an agent, in order to get the stringent, like a wiretap order, they have to go and convince an Article 3 judge that there is probable cause for the court to order that. Right now, the Patriot Act also created something that is just, with a letter, they can just go to the provider and get the information. So it pretty much waived the significant and the detrimental part of the Patriot Act as it regards American citizens is that it did away with their constitutional rights, particularly the Fourth Amendment. And so no longer was probable cause required or an affidavit before an Article 3 judge. That even though they obtain it before the person finds out, obviously, because then it would, they might lose the evidence. The truth is that when it's an Article 3 issued warrant, you have an opportunity to find out about it. When you get all these FISA warrants like that congressman did, you don't ever find out that they were surveying you with a FISA warrant, that you never find out. So that's the basic concept, is that the Patriot Act did away with the Constitution, not just for foreigners, which is what it was supposed to do, as we're going to talk later in the next one, but because they're not covered by the Constitution, right? But for Americans that became the target of the surveillance.
I understand. This is exactly what I was saying before. If you are going to get away with the Fourth Amendment, say it. Don't hide it. Say it. So we are all on the same page and we don't have to fight for it. So the only list of people it contemplated was to screen immigrants' requested visas. That's Section 414. That was the original plan, and obviously then it expanded to the U.S. American citizen. That expansion, was that a part of this sort of reconstructing the Patriot Act?
No, some parts just expired. Some parts were like emergency provisions, and they expired after the emergency. However, we originally got into this topic because, as you put in the first slide, many people think that the TSDB is a part of the Patriot Act, and it's not. The Patriot Act was enacted in 2001, the TSDB in 2003. And it was not an act of Congress. Instead, it's an executive order because Congress, you have to wonder, why did Congress not pass a statute authorizing the TSDB? You have to wonder that. So if it had passed the Patriot Act. And so what the Patriot Act does do in terms of lists, the only list contained here was they had for information sharing and counterterrorism, but it was for the people that were asking for visas, and it was information sharing with the State Department. And then they implemented, we're going to see probably in the next slide, how they implemented a very crucial aspect of what we're suffering today, which is it was the Patriot Act that authorized the distribution of this intelligence information to non-law enforcement. What the real database that they talk about in the Patriot Act is about the visas and the people applying for admission to the United States, that they wanted to make sure they had no ties to terrorism, but it had nothing to do with the terrorist screening database.
Yes, and of course, with the open borders now, it almost doesn't matter if you are on TSDB or you're not. We know that for a fact that people on TSDB are coming through the border. So let's see, what is the Section 701?
This is what I was mentioning right now, which is it's expanded the scope of the distribution of the counterterrorism intelligence to non-law enforcement entities, such as the 532 biggest corporations of the United States and 1,440 organizations. And what that means, as it translates to us, is that it was the Patriot Act, and then because the Omnibus Crime Control and Safe Street Acts of 1968 is the one under which the states and federal government and tribal governments and agencies like the TSA can have what they call the projects. And those projects are lists of criminals. And now we know that in the context of the TSDB, they don't have to comply with the reasonable suspicion standard that the law imposes, that Omnibus Crime Control and Safe Streets Act of 68 imposes, that before you put somebody in any list, you have to have at least reasonable suspicion. But as I read last week, there is, the Attorney General can do an exception, and I have already done a FOIA on that, an exemption of any of the requirements under this of the projects done under this list. So the important thing here is that the Patriot Act authorized that the information sharing at that time of intelligence be given out to private enterprise, and that is what it has been made possible. The Stasi state we are living in on now, because you have people like Neighborhood Watch and Citizen Court and InfraGard and many other private institutions that collaborate with these people that deem anybody on the TSDB as a suspected terrorist and treat them either with disdain, hostility, get to, do the things they do in advancement of the goals of the program. But it's under the guise that, oh, they're terrorists, they're suspected terrorists. It's okay to violate their rights.
Yes. This situation, it's simply incredibly unjust and incredibly wrong, and we're analyzing it, but it's just so obviously wrong that I can't name that emotion. It's a feeling of incredible injustice.
It's indignation and impotence.
Yeah.
Injustice, indignation, and impotence, because we know that they are violating the law and they continue to do it. Catch me if you can. They continue to hack. They continue to do the illegal things they do with absolute impunity. They really think they are above the law, as they have been, acting for the past, I think everything got worse in 2008, but, for the past 2 decades almost.
So I think this slide summarizes the very essence of that question: how does Patriot Act and TSDB coexist? So even though Patriot Act establishes the basement for the investigative and surveillance activities in violation of the 4th and 5th and 6th Amendments under the guise of fighting terrorism, it does not authorize the terrorist screening database. And specifically, it doesn't allow the inclusion of American citizens in the database. It doesn't authorize change of the compliance with reasonable suspicion. Nowhere does it say that. And it does not allow for the dissemination through the National Crime Information
Center that is administered by the FBI.
Center. Yes, those are the 3 elements on which the TSDB stands, and they're nowhere in the Patriot Act.
Exactly. Like, you see, Congress, even in the Omnibus Crime Act, they were so careful to make sure that, okay, we're going to authorize these lists, but you have to comply. You have to, first of all, protect the privacy rights of people. And second of all, you have to make sure that before you put somebody on a list of any kind, you meet the minimum requirements. And that's exactly what it's not being done with the TSDB, and just spreading this information to everyone that, everybody, like Kayla Kay said in her video, even the gang stalker on the street has access to the list except for me. Everybody has access to it except for targeted individuals. And what has happened when we do the Privacy Act requests, they cannot confirm or deny, and that's part of the reason we're in court. So none of this. Yes, I'm not saying that American citizens are not allowed to be on the TSDB. I'm not saying that, because that would be an incorrect statement. What I'm saying is Congress did not authorize the TSDB, and the place it has gone, certainly the place it has gone. And it is time for Congress to do something about it. First, by at least defunding this special access project that it's clearly illegal and in violation of everybody's civil rights.
I have a couple of slides that are devoted to TSDB, and I'm just going to go over them quickly because we've done this before. Once again, creation of the TSDB was a result of the executive order of Homeland Security Presidential Directive number 6. That was in September of 2003, as opposed to the Patriot Act that was passed in 2001. It instructed the Attorney General to establish an organization to consolidate the government's approach to terrorism screening and provide for the appropriate lawful use of terrorist information and screening process. That executive order doesn't even tell that it's the FBI who would be doing that. It just says, Attorney General, you figure it out, you consolidate it, and you figure out which organization would tell you. And what's probably the most important part to me and to the future litigation that we will see in the TSDB arena, that this executive order does not identify any particular source of law that authorizes its mandate and states that its term to not alter existing authorities or responsibilities of department and agency heads to carry out operational activities or provide or receive information. It says it's business as usual. Distribution of information is usual. And by the way, there's really no law that authorizes it. This is just my executive director. So AG, you go figure out what's lawful. As a president of the United States, you write an executive order, you have to tell us what's the judicial foundation for your order is. It can't just appear out of nowhere. And that's what it looks to me, that it just out of nowhere, it's like a magic trick. Boom, now it's here. And we need to know where it came from.
And that's exactly the argument that Mr. Abbas has done in Kovac v. Ray, is this is a major questions rule, and this is the TSDB is something that affects so many aspects of anybody's life that it had to come from an act of Congress. They couldn't just pull it out of their sleeve like a magic trick. And even the Homeland Security Presidential Directive 6 requires that reasonable suspicion, which is not enough. It does not meet the probable cause burden for anybody to be in any kind of these lists, because I think that it's too low of a standard for protecting people's due process, substantive and procedural due process. But that's another thing. Like you just said, they pulled it out of a magic trick sleeve, and it had to be an act of Congress.
Correct. And I'm hearing these arguments from some journalists that, well, the TSDB legality is a closed question. And by any stretch of imagination, if you've been following the current cases, if you've been following Kovac v. Ray, if you've been following what's going to happen on January 8th in the Supreme Court, It is not a closed question, so you are simply uninformed. As a result of this executive order that said, Attorney General, go figure out who's going to do it, the resulting organization, the Terrorist Screening Center, is administered by the FBI in coordination with the DHS, DOJ, and the Office of Director of National Intelligence. This is how the Attorney General set it up. The TSDB is shared with different various partners. And what does it do to the nomination process? The nomination process, the ultimate decision to be in the terrorist screening database is given to the Terrorist Screening Center, which is the FBI outlet. And it gives that organization the ultimate decision whether an individual meets minimum requirement for inclusion on the watch list. But we know that it goes way beyond the category of terrorist and suspected terrorist.
All the research I carried out prior to filing this lawsuit, which came from the El Haiti versus Cable case, stated it let me know the following: that the watch list is only composed of the handling code 1, which is a known terrorist, handling code 2, which is the suspected terrorist. So when they refer to the watch list, they're really not referring to the TSDB, because it doesn't include handling codes 3 and 4, which are not supposed to exist. And that those are the people that don't even get stopped at the airport. So when you talked a little while ago about the closed question of, it's a closed question, the legality of the TSDB. No. There is no closed question when it comes to the fact that, yeah, the watch list is one thing, but having innocent people that have absolutely no connection to terrorism on that list, that is an open and shut illegal conduct. And it's not authorized by any aspect of our constitution or law. So, any journalist that you encounter and say, okay, fine, what if the persons in the watch list that are handling codes 1 and 2, which are the known and suspected terrorists, they meet supposedly the reasonable criteria, reasonable suspicion criteria, fine. But what about the ones that the FBI has admitted that don't meet their reasonable suspicion criteria and do not represent a terrorist threat, and the proof is in the pudding? That is why they are not screened as such at the airports. No journalist can tell you that that is kosher. I'm sorry, because it's completely illegal.
Yes. Correct. And their legal challenges to the lawfulness of TSDB. We don't have to go very far. In the same Fifth Circuit that we're in, there's a case called v. Ray. And it precisely argues before the U.S. Court of Appeal for the Fifth Circuit that under the major question rule, the TSDB had to be an act of Congress, and it is not. The central argument is that Congress did not authorize a watch list that allows agencies to regulate the daily lives and liberties of Americans. Literally, every step that we have to make is affected by being on the TSDB. And another argument regarding the connection of TSDB and the Patriot Act is nowhere in this case the plaintiffs, the Mr. Abbas, arguing for the Mr. Kovac, make a reference to the Patriot Act. And not only that, the government defendants nowhere in their writings and their filings make a reference to the Patriot Act. So if there was a connection, that would be front and center, and it is not. So, like I said in the beginning, the short question, are they connected? No, but there's a longer question and there are caveats.
But what's important is exactly, it has no connection. The TSDB, other than, the counterterrorism and intelligence collection, whatever, it's not an act of Congress. And the Federal Register that authorized its existence, which I, you know about it. It's I think I sent it to you, 58 Federal Register. Well, that demands this reasonable suspicion. So under both Mr. Kovac's challenge to the TSDB under the major rules, but obviously his case regards the watch list, the known and suspected terrorist part of the TSDB. But under his theory, as well as the theory we have presented, that you don't put innocent people, non-terrorists, on a terrorist database. On both aspects, it's flawed, and they have to bring it to an end. I think that the court is going to have the two major, and it's amazing. If we had planned it, it wouldn't have happened that way. But it is amazing that these two cases are before the Fifth Circuit right now. TJ v. Garland and Kovac v. Ray.
Yes. Synchronicity is really a thing, is really working. It all comes to one big culmination, and we will have our day in court. We will have all our questions answers. I believe that in my heart. So the conclusion, the Patriot Act, did not authorize the TSDB. The TSDB was an executive order that morphed into a monster to steal away civil liberty. Beautifully said, Anna. And I hope we did a decent job explaining it to our viewers. With that, why don't we take a look at the video that CBS produced this week? And it's highly relevant to the topics that we are discussing. For the second part of the show, we plan to show you a CBS News clip that talks about TSDB. It has been made available, publicly available, only a couple of days ago. And I watched this. I think perhaps it was a part of Targeted Justice newsletter on Substack. What happened today is that I'm not able to play this video. It's been completely blocked. I try a couple of different browsers, but I will post a link to this video in the show notes. So please go watch that video. But I would like you to listen to Anna's comments about that video. So this is the best we can do today. We are under serious electronic interference, and we're gonna do our best. So Anna, please tell us what the video is about and what the key takeaways you would like our listeners to take from it.
Well, it's great, because I'll do the spoiler alert. The first thing I need to say is this. I think that mainstream media, the fact that mainstream media, that CBS is covering the abuses of the watch list is a huge, great thing, because they were not touching this with a 10-foot pole. And even though it doesn't go into the targeted individuals or any of that, still it denounces the abuse that the watch list represents for innocent people that have absolutely no ties to terrorism. So they talk about, in fact, it's titled The Watch List. And as I mentioned to you before, in the research I carried out with all the documents that I've been reading, both audit reports and the documents produced in the El Haiti versus Cable case, the watch list component of the TSDB is handling codes 1 and 2, which is the known terrorist and the suspected terrorist. So when the reporter in this case says that he has corroborated that the watch list is comprised of 2 million names and identities, what that tells me is that we have severely underestimated the amount of targeted individuals that there are, because the watch list part, as of the audit reports I have read, the watch list part comprised only 0.29% of the entire TSDB. So just do the math on that. If that 0.29% has blossomed into 2 million people, so how much is the other 97%? That's one thing that I want you to keep in mind. The attorney for ACLU that appears, she says something, she's so concise, so perfect, and so beautiful. And she goes, you have no meaningful process to clear your name regarding something that you have never done and will never do. And that's just, it's just perfect. It's just 7 seconds of perfection. It's the best quote in the entire, for me, in the entire video. Also, it is important how one of the creators of the TSDB, that when you look at him, he just looks like he came out of a Dick Tracy movie, but the evil guy in the Dick Tracy movie, I don't remember his name. Well, he says it's an enterprise, it's a business, and that's what exactly, that was like a Freudian slip, because that's exactly what the TSDB is a means for people to earn money without doing anything other than harassing and stalking people. You can be from the chair, from behind your screen, hacking people like the InfraGard people do, and following people around in your car and getting $20-$30 for that. God knows how many it is that they get paid for. And I really urge you to just from minute 440 to 546, basically tell on themselves. When you have, like our audience has learned so much through watching this about, the ins and outs of this TSDB, it is interesting that the reporter doesn't even begin, he's even aware of the fact that there is two subcategories of the TSDB that include completely innocent people that don't meet the reasonable suspicion standard. Of course, he doesn't ask about it because he doesn't know about it, because he hasn't bothered to read TJ versus Garland, like most mainstream media. But I have to commend him that he did, as it pertains to the watch list, he did an okay job, although I wish he would have covered the recent challenges to the watch list, which is the FBI versus Fiker, which is in the Supreme Court, and that is news, and the Kovac v. Ray, which is in the Fifth Circuit, and that is news. So he just leaves it in a limbo, like, oh yeah, the man that appears in the video filed a legal challenge, but he doesn't talk about all the prior legal challenges and the current legal challenges that are so viable. So kudos to him for tackling on the subject, but there is still a lot more work to be done. And in the Substack newsletter, it was interesting. Richard Lighthouse emails to the other 3 people were blocked, but it is, if you look at the Substack newsletter that reported on this article, on this report, I urge you all to send an email to those producers, very respectful, and don't make it about yourself. Make it about the illegality of including innocent people on the terrorist database, and for reporters to press the agency, the Terrorist Screening Center, that Mr. Glashin didn't have the guts to be on camera. He just sent a written statement. For them to force them to answer the questions, because the mainstream media, if they are waking up to the reality that innocent people, including infants, are being placed on this terrorist database, it is time to act. It is time to denounce the illegality and the atrocious obliteration of human and civil rights that's going on. So they don't have to go into the fantastical. Please don't. Just write to those people and let them know that there is so much more that they have to report on. That's my plea to you. You know how I'm always saying, what did you do today to end your targeting? Here's a great idea. Write an email to each and every one of those very respectfully and make them aware of the silent Holocaust the targeted individuals lived through here in America.
Beautifully said. I support you asking people to do something about it. I support your sentiment that don't make it about you, even though it's so hard not to, because it is happening to you. It is happening to all of us. And yet the mission is so much bigger than us. So we have to dedicate our efforts to the mission than rather than to our personal well-being, which is hard, but it has to be done. If you had a chance, this week we had a board meeting and an advisory board meeting, and I will also post links to those events. Please take a look. A lot of people have questions about targeted justice, and the sincerity of our efforts. Please take a look at these videos and tell me, do you trust people who devote so much time, devote so much effort, their personal time, without being compensated? Being on the board of director of Target Justice is not a cushiony job that somebody think it is. It is a lot of sweat. It is a lot of work. It is a lot of stepping over your own interest. And if you are one of those people, please volunteer, please donate, please be a part of the history. We need help in any avenue that you can imagine. So your talents, your donations, and your support are highly appreciated. Anna, would you like to say a few words at the end of the show?
Yeah, I this week I was also I don't know if you saw, I was with Jeffrey Prather, and I have to comment that, as you know, we had severe electronic interference even in our advisory board meeting, and that's just it's an annual review of our accomplishments, and criminal hackers didn't want us to shine through it, but it doesn't matter because our work is there. And people have seen, I just asked people to look back a year ago, where were we? And look now where we are. And it is targeted justice has a lot to do with it. Targeted justice has a lot to do with the fact that right now the word targeted individual is no longer taboo and is being mentioned and talked about publicly. Jeffrey Prather put it very nicely this week when he interviewed me, because he's a TI as well, and he said, "What, as a media person, if you want to have the media listen to you, be very coherent, be very self-controlled. Just project yourself that, like it's not just about you." And that's why I emphasize it. Let's make it about the future that we're going to leave for our children. Right now, as you and I know, there's infants, there's toddlers, there's children that are attacked, not just with microwaves, but also with V2K. And we have to do something. We owe it to them. We have survived all this, not in vain. We owe it to them to leave a better world. And, legislators, judges, politicians, they have to become aware of this fact. This atrocity cannot continue. So in order to make our voices heard, please do so in peace, coherence, and calm, and with the facts. Timothy Grove, former deputy director for the Terrorist Screening Center of the FBI, admitted that there are people on the terrorist screening database that don't meet the reasonable suspicion criteria and are not screened as such because they are not a threat to national security. I wish every TI would memorize that and just tell it to everybody they can, because it's a huge violation of civil rights. And that's, sorry, I was long, but I had to say it. Just please memorize it and say it to everybody you can.
That's a wonderful idea. I will make an effort to memorize it because I was struggling with that sentence earlier. Thank you for that monologue, and thank you for your predictions. It's hard to make predictions, especially about the future and when we're actually going to be liberated. But I can make a prediction for the near future that every Sunday we will be here, rain or shine.